A very good evening to all of you for joining in this amazing yet interesting webinar. Well, as excited as you are, I'm equally excited because this is not a very conventional topic which generally our law schools would teach or generally our professors would teach. And this is why we are here. And what motivated me personally to bring you up, bring you with this webinar was the current state of privacy in India. Yes, we're living in the flux. We don't know what's going on. The government is acting up weird, and who knows what's going to happen. This is why it's very important, even if you don't want to make a career in privacy law, it's important to be informed because right to privacy is also a right to life, right? And today we have Tapan Tyagi, who currently works as a data privacy consultant in one of the top 4 consulting firm in India. He is a seasoned consultant in the field of data privacy and protection with a strong belief to have privacy embedded at an organization's course. He has catered to clients across various industries by building a robust and sustainable privacy program. His knowledge and skill set spans the technical management and legal forte as well, and his close association with the International Association of Privacy Professionals has always proven to be resourceful to his clients. He holds prestigious certifications such as CIPPE and is a One Trust Data Fellow. Thank you so much for joining in here, Tapan, and it's great that you were able to give in some time from your busy and hectic schedule and contribute to the society back by informing them about what is privacy. So guys, with this, we'll be starting our webinar. Just few tips and few instructions which I would like to give. If you have any question, if you feel there is an issue going on, if you have a question, if you have a query, please use the Q&A box. And guys, we have a surprise for you. Yes, Loctopus Law School has brought a small surprise along with this webinar for you. So we request you to stay here till the end of the webinar. And after that surprise, Tapan also has a surprise for all of you. So indeed, this is a very fruitful webinar for all of us. And with this, let's get started. I'm going to start sharing my screen. Again, if you feel there is any trouble with my screen sharing, if you feel I'm frozen and you're not able to hear the speaker, please use the Q&A box since chat is disabled, but you can use the Q&A box for the queries as well. All right. Tapan, do you have few words before we start?
Yeah, definitely, Ashna. Thank you so much for the kind introduction. And I would like to thank Loctopus also for giving me this opportunity because essentially there's not much knowledge out there in the realm of privacy law and there's a lot happening. So I just wanted to put the knowledge out there for the students and the attendees of this webinar. So thank you so much.
Awesome. So guys, I'm just going to start sharing my screen. Tapan, are you able to see my screen? Awesome. Awesome. So over to you now, Tapan.
Okay, thank you, Ashna. So hello, everyone. As Ashna introduced me, I'm Tapan Tyagi. I'm working as a consultant, data protection and privacy consultant in one of the big 4 consulting firms. And today I'll be talking about privacy in law and specifically careers in privacy law. In this particular presentation, I have charted down the history of privacy law, what are the current status of the GDPR, what are the rights, what are the principles mentioned in the GDPR, how GDPR evolved. So basically in this particular presentation, it will be a mixture of your philosophy of law, and I will be constantly giving up scenarios from my experiences and examples.
Tapan, you're on mute.
Oh, so sorry.
No worries.
That's a classic hiccup, which happens in these types of meeting webinars. So yeah, hi everyone. So I'm Tapan. So as introduced by Ashna, I work as a data protection and privacy consultant in one of the big 4 consulting firms in India. And today in this webinar, I'll be talking about privacy law, how privacy evolved as a concept. And specifically, I'll take your Q&A sessions as to what careers in privacy law are there in the market. So basically, this particular presentation will be a mixture of philosophy behind privacy, how privacy started, how old privacy is, and it might come shock to many of you. And what is the current status of GDPR? What are the practices involved? What are the industrial practices involved? How to get your certified? What is IAPP? And exam details, a little bit of exam details. So that's all what you have in this presentation. So Ashna, we can move forward to the next slide. Yeah, so introduction to privacy law. In India, generally, when we talk about privacy and data protection, we think it's something new which has come up because essentially we are not a very privacy centric society. In our culture, there's no concept of privacy. So if I come from northern India, so I've seen how my parents' generation interact, right? So my dad often used to get questions from his friends like, "Beta kya kar raha hai? Tyagi ji, aur aapki wife kaisi hai?" But in Western, it is not. So sometimes if you ask that kind of a question in a Western society, you will get a weird stares from the other person because they don't want the other person to intrude into their private life. So it might surprise you that the privacy evolved as a concept in this particular case and way back in 1604. This is the famous case of Semen. So essentially what happened in this case, the whole case citation is Semen versus Gresham. So essentially the facts, as this is a law octopus, so I think that whole case-based scenario will be, audience will be familiar with the facts and how the case proceeds, what are the ratio descendant. This is the assumption I'm taking, and what is the obiter dicta of the cases, such Latin maxims. So I hope that audience understand that. So the fact of the case goes like that. So the Gresham, and there were two guys. One was Gresham and Bresford. They were living jointly in a London in a flat. And Bresford was in a business of goods, and he used to store goods in this particular flat. So this second guy, Bresford, was in debt to a person named Seaman, the Seaman case, the first party in this case. And the judgment was entered against him. And it was issued that the Seaman has a right to recover his debts from Bresford. Meanwhile, when this execution was going on, Bresford dies. So essentially, leaving his flatmate, Gresham, alone, the owner or the tenant of that flat. Now, when the sheriff of London, because at that time London police was called sheriff because it was under King George IV. So at that time, sheriff, when they got into his house, Gresham did not allow them to enter his house in order to take the goods, which were basically Seaman wanted to enforce that deed because Bresford took loan from him. So, but the deed was not executed because Gresham did not allow them to enter. So this case reached to the court. Then court held that, and this is a very famous saying, the house of everyone is to him as his castle and fortress. So essentially, enforcing the right of Gresham that even the police does not have the right to infringe his right to privacy because right now he is the owner of the house. So nobody can invade, even the state. And even if the state has to invade, they have to take permission of the court for the due diligence because under this execution deed, it was vis-a-vis Bresford in debt. So in order to get the goods from Gresham's house right now, you have to approach the court again in order to take that. You simply cannot have a reason or a proportional, you have to have a proportionate reason. So the right to proportionality, now we are discussing in the Puttaswamy judgment, right? This right to proportionality was dealt in sort of a little way, ratio descendi, of this particular case. Now, first, this is how the privacy as a concept first, which we in modern day trace back its roots is in 1604 in this famous case of Seaman. And I recommend all the law students to go through this case once, if at all you want to build a career in privacy law, because this lays the foundation of privacy law. And not just that, it's a good reading also to read. It's a good case law. I'm pretty sure many of the law schools are dealing with this case law. Now, fast forwarding to 1948, we have Universal Declaration of Human Rights. And this is like the statutory backing of United Nations, in which Article 12, which essentially talks about your privacy, arbitrary interference should not be there. in vis-a-vis the individual privacy. The individual's private life, state has to abide by certain rules or guidance, which are essentially not mentioned in the UDHR, but will going forward we will learn what all the guidance and what all the rights of the data subjects are in GDPR. But more or less, this laid the foundation of human rights, involvement in privacy law, and right to privacy, and how right to privacy is a fundamental right in India. In India also and worldwide also, in many countries they have mentioned the right to privacy as a fundamental right. And in India, after Putta Swamy judgment, it is a fundamental right. Now, after UNHCR, you have guidelines of protection to data protection of privacy and trans-border flows of personal data in 1980. So essentially, these guidelines were brought in by OECD, Organization of Economic Cooperation and Development. So majorly they were EU focused only, because essentially it was the EU market which they wanted to tap on, and how the data should flow in and out of those guidelines. So basically these guidelines gave the basic definitions of terms of data protection law, which we generally now talk about, right? You have data controller, the person who's determining the purpose of processing of personal data. You have data subject, whose data is being taken from him by the data controller. So all these terms and nomenclatures, you will be able to trace back their roots in these guidelines of OECD. They sort of defined the concepts, the principles of data protection law, the modern day data protection law, which is GDPR. And many of the principles, like, as I mentioned, of data protection are borrowed from these guidelines. Then in 95, we have something which the European Parliament did. It was, they adopted a directive principle, 95 by 46 by EC. So essentially, this laid down the procedural requirements of data protection law. And this sort of give a push to each and every country in the EU to make a national data protection law in sync to these directives, right? So essentially these directives, like for the first time, they dealt with the concepts like notice for data, purpose, consent, security, disclosure, access, and accountability. So all these principles, all these procedural aspects of data protection law, which we see in present day, which I see continuously in my practice whenever I'm dealing with clients, their problems and everything, all these terminologies can be traced back to this particular directive. And the first and like sort of a glimpse of how old the privacy law is, or how it is sort of not a new concept. In India, it might seem new to us, because essentially what we do is cut, copy, paste, control C, control V from Europe or American countries. But it is not. For a Western society, it is not a new concept, because Germany is the first country in their particular province of Hessen. They had their first law in 1970, wherein they recognized the need for the data protection, especially personal data protection, that the information which the person is sharing with other people can be detrimental sometimes, and how it can be infringed, and how other means can be achieved from this particular personal information, followed by data law of Sweden 1973. So it revolved around the similar lines as to the data protection law in Hessen in Germany, talked about sensitive personal data and personal financial data. But in US and Canada, we have a different trajectory altogether. So a US is very sector specific. So they came up with this Privacy Act in the Fair Credit Reporting 1970 and Privacy Act of 1974, and they have some general accepted privacy policies also, which essentially were framed vis-a-vis your accounting principles in order to protect the accounting data of an individual or an entity, so that nobody else has an access to that, or their trade secrets, or how many money they are making. So that's how it evolved in US and Canada. So Canada has this national standard, Canada Council and NIST, FedRAMP frameworks, which essentially talks about a sector specific. So, and when I'm talking about sector specific, Essentially, there is a HIPAA also. There's a Health Information Related Act, Health Information Privacy Accountability Act in US, which essentially deals with your health information, how to deal with it, what are the limitations. So US and Canada have focused on a more sector-specific approach as compared to EU, which has more broad legislature like GDPR to maintain and safeguard the sensitive personal data or personal data of their their citizens. So that is the difference between US and EU GDPR. So just reiterating my point that privacy is not a new thing as you might see in the newspapers and all those jazzy fancy lines. It is an old concept and it has been discussed a lot. Yes, there are modern day challenges, scenarios which we face daily, and we have to look in order to look up for the solutions of the same. We do refer to all these principles and how it will be dealt, keeping these principles in mind. Asha, you can skip to the next slide. Yeah, so the GDPR history now. So GDPR evolved from a treaty, and it was basically signed by everyone except Turkey. Turkey had their own reasons why not to ratify it. It was majorly political reasons. There was no such technical reasons as to, they did not pinpoint any technicality, any technical fallacy in the treaty regarding the protection of individual rights with regards to automatic processing of personal data. So basically, with what is automatic and what is manual, essentially there are two types of processing which carries out in an IT firm. One is manual, one is automatic. So what I mean by this is like, okay, let's take a scenario. You have applied for a loan in a bank, right? Bank has an algorithm which runs and discards you or says that you're not eligible on the loan based on your previous defaults because you have defaulted in previous loans. Now the algorithm has rejected your loan, right? But a man might not reject or might seek more information as to what were the reasons why you defaulted. There can be n number of reasons, unforeseen circumstances, force majeure clauses, whatnot, and it was not your fault. It might not be your fault to full extent why you did not repay the loan, right? So there can be, or you might have been given some subsidy on the loan and whatnot. So let's take an example where algorithm has rejected you, but a manual person might not reject you or might seek more information. So that is the safeguard which was being provided in this treaty, and this we can see in GDPR also right now in Article 22, and I'll talk about it in the later slides of my presentation. Now, this directive was this I talked about in my earlier slide also, 95 by 46 EC, with processing which regards to EU member states to formulate national laws in line with it. And the special focus was on to recognize privacy as a human right was made, because some countries, mostly Eastern European countries, were not that enthusiastic, so to speak, to make a privacy a right, because that would again infringe on their functionality of state or regulatory state. So there was a constant debate which was happening in the EU Parliament as to whether we should make it a privacy law or a part of human law or not at all. The very same time, revisiting. Although UNDHR was applicable on all the EU states, but still there were some, things which they wanted to consider vis-a-vis maintaining the privacy law. Then you have Article 29, Working Party. So essentially, this released a Future of Privacy paper as a response to the invitation for consultation. So essentially, what this paper talks about is the future technologies which we are dealing with right now, or which are making very buzz in today's world, your metaverse, your this webinar scenarios, right? So this all were being discussed in this paper, and how they will be privacy infringing of an individual, and what all safeguards to be provided to an individual when he or she is in the privacy in this realm. So I will go forward and just elaborate on this particular paper, because this is a must for anyone who is interested or enthusiastic about privacy law and has his or her wild horses running as to what can be the future scenarios where privacy of an individual can be challenged in the court of law, or where a technology or system can be challenged. So in a recent case, in Danish supervisory authority banned Google Analytics. I don't know how many of you were following it. So essentially what happened was that they did not ban Google Analytics per se, but internet was swarmed with the post that Google Analytics banned in Denmark and whatnot. But they did not ban Google Analytics. They essentially banned a particular function of Google Analytics by the Danish municipal corporation. So essentially that functionality of Google Analytics is still there, but that cannot be used by state or state bodies to do a surveillance of their citizens. So that is the crux of that particular judgment. So essentially this paper is very interesting, and this is what Ashna was talking to you also about the surprise. I'll share it with Ashna, and let's see how she wants to distribute this paper. It's a must read for each and everyone who wants to build a career in privacy law and who wants to, imagine various scenarios based, because in practice I generally what I like to consider myself is a problem solver, because client does not come with a simple Excel to just make him or her a GDPR compliant, right? They have a lot of processes in place. You have to check and evaluate each process, and this particular document helps you a lot while doing the field job, so to speak. Then essentially in 9546 EC, you again have a comprehensive. This is like the discussion of 95 being taken forward to 2011, because during this time there were many talks about how we have to govern the personal data protection, because there were many Chinese threats which the EU data, there were many data breaches and cyber attacks from the China's end on EU, which were infringing EU citizens' data protection laws. So essentially, they took a commission and formed a dedicated group wherein they talked about all this in detail, in great length, as to what should be the data subjects right, what should be the framework of international data transfer, what are the tools which should be used for data transfer, and all of that. Then we have GDPR 583, first draft of GDPR. So it was a very rudimentary draft, so to speak, not like we see it today. So today we have like somewhere around 100 articles in GDPR. It was essentially it laid down the foundations of GDPR principles, what can be the data subjects right, how to accommodate DPIAs and PIAs. So by DPIA and PIA, I mean your data protection impact assessments and privacy impact assessments. It's a concept in GDPR, which I'll be dealing with in the later stage. Now, moving on to the reforming data package. So it highlighted the improvement. So it was done in collaboration with the Polish law firm and a German academics. So it is also a very good read, because essentially they were at that time in 2012 discussing how to chart their way out of a technology. So the famous saying as it goes, law always try to catch up to the technologies. And to be very honest, I still don't think so that law has catched up to the technology, because technology is way ahead than law. And we constantly, as a practitioner and even the supervisory authority bodies, face the same challenges, that it's difficult for law to catch up, and it's difficult. Sometimes we don't have answers to each and every technological challenge which is being posed to us. So it is there where all these discussions were taken into account, and they discussed the data transfer. They came up with the tools of data transfers, how to transfer data across EU and vis-a-vis other continents as well. So yeah, Asha, can you move on to the second slide? Thank you. So these are the few 7 principles which are there in the GDPR. So the first one, and it is in the Article 5 of GDPR, the first one is lawfulness, fairness, and transparency. So this lawfulness, this essentially talks about in the sense of processing your personal data. So what lawfulness of personal data is being dealt in Article 6 of GDPR, which essentially talks about what and how to determine the lawfulness of processing of data. So the first thing which is being mentioned in the lawfulness of processing of personal data is your consent. That the data controller, let me just lie down some foundational works and define some foundational terms for the audience here. So whenever I'll speak about data controller, that will be the person or legal entity who is collecting the data and determining the purpose of its processing. And whenever I'll say data subject, it is the person, individual from whom the data is being taken by data control. So now that being said, the first lawfulness principle, which is mentioned in Article 6, is consent, that the data subject should consent to the processing, which will be done by data controller. Right. So from a very rudimentary example, we all consent when we are browsing on internet, right? And I don't know, like there might be trillions of clicks or touches which you have set to that I agree button without reading their privacy policy or how they use data. I'm guilty of that. I've done that. So yeah. So that's how things work, right? And you have to consent, and that's how companies show that the data subject has consented. So the consent is very important. Then there's a contract. We all are lawyers. We have read Indian Contract Act 1822, and we know what are the obligations. So there should be a contract in order to process the data of a data subject. If there is no contract, then you have to go for legal obligations. So your data is being processed by tax authorities many a times whenever you file a return, right? So in this scenario, your tax authority becomes a data controller and you being the data subject. And you have they have a legal obligation to process your data, to check your returns, how much to refund you, right? In that case, they have a lawful basis to process your personal data. Then comes the vital interest. So vital interest is basically whenever it is life threatening. So supposingly data subject is in a subconscious state and a hospital needs to determine his or her blood group in order to arrange for a donor, right? In that case also, taking out his blood and processing that blood amounts to data processing. So, and identifying his or her blood group will come under the vital interest. And there's again another one, which is public interest. So this is essentially a state arm or state tool, so to speak, where state can use or process your data in the garb of public interest. So yeah, it's a bit a controversial clause in GDPR, but it is present there. And another controversial one is the legitimate interest. So the prior one was for the state to use as a tool against a data subject or individuals. This one is for the companies and the corporates, which is your legitimate interest. So what companies do is whenever they take any data, and this is a general practice which I've seen, that they cover everything and anything under the sun related to you, and they can use that data for all these purposes. But there are judgments coming up now that you have to follow other principles like purpose limitation, and the court has instructed companies not to use data in an controversial manner, which data subject can later pinpoint to. So yeah, these are the 6 lawfulness principles which are mentioned. Now the second one is purpose limitation. So by purpose limitation, it means that data controller should only collect that much of data which can fulfill the purpose which is mentioned in the contract. Self-explanatory, right? Data minimization. So there should be an conscious effort on the part of data controller to minimize as much data as he or she can, so that the information which data subject is giving and the work gets done in the minimum information provided by data subject. Fourth one is accuracy. So there's a duty or obligation imposed on data controller that you have to maintain accurate data. And this is where the privacy professional practitioners come into the picture, because there needs to be audits performed after every sort of the periods allotted where internal audits are performed, your data audits, your privacy audits, where we do check the accuracy of data vis-a-vis its retention schedule and other things. So this is also an area for privacy professionals to look up for. Then there's storage limitation. So GDPR has imposed this obligation, and this is a principle that you have to store in a certain format sensitive data, personal data, and non-personal data in a certain format, so that it is secure and everything. So you have standards like ISO 27001, 27701, and you have to abide by those standards. And storage limitation, these are retention schedules also, which are being given by many supervisory authorities. Then you have integrity and confidentiality. So it is pretty evident, like whenever you are collecting data, you have to maintain its sanctity. You have to protect the data from data breaches, from cybersecurity threats, and you cannot afford any unauthorized access to sensitive data or personal data also to a certain extent. So there are charters within the organization which are maintained within the organizations. So, and those charters are being followed religiously, because these charters are audited by data auditors and privacy auditors when they go for an audit. So these integrity and confidentiality, and if are not taken seriously by the data controller entities or big IT firms, they can get imposed fines. Hefty fines are there, 4%, and you might be seeing that in internet also. So yeah, the fines are pretty huge. That's why the compliance work is heavy on us privacy practitioners. And the seventh one is accountability. So in order to achieve accountability, you have to have a dedicated privacy office. And by privacy office, I don't mean that it should just sit in a corner. There should be a proper management hierarchy over there. So you have now I've seen a corporate practice where there are people who are being appointed at the CXO level. You have chief data officer, or you have chief privacy officers in an organization. Infosys has appointed, and I think in India, Infosys is the first company which has appointed a CDO, chief data officer, Mr. Srinivasana. And since even pre-GDPR era. So that's quite a pride in which we should take, because today I think is the founder's birthday also, Infosys founder's birthday. So that just came up in my mind to share it with you. So that's how privacy is being taken seriously in few Indian organizations. Infosys I named, but in EU and other international organizations, they are taking privacy really seriously. So, and why they are taking seriously is A, because of the fine, and because of the seventh principle, which is accountability. So yeah, Ashna, we can move on to the second slide, I think. So here we talk about the data subject rights. So there are rights given in GDPR. These are some of them, and some of the rights also, enumerates from other articles as well. But these are the primary major ones which you'll find in GDPR. Why I said that some of the articles enumerates from other sections of the practicing, because sometimes supervisory authorities issue a specific circulars which give access or data subjects more right than these mentioned here. So I'll take each one of them and explain briefly about each one of them. So first one is right to access. So data subject has the right to access his or her own information from data controller. So whenever, and this is a very layman examples I will give for the better understanding of the audience. Whenever you go and inquire about your orders on Amazon, what is the delivery status of your order? You are exercising, my friend, your right to access there. Right. So similarly, right to rectification. Whenever you, and this is whenever you place an order and you have placed by mistake wrong address, you are exercising your right to rectification, your information, your personal data, when you have entered a wrong address and you want to correct your address. So you are exercising. By you are, I'm saying that the data subject is exercising. Right now in India, we don't have a dedicated privacy law. So right now everything is in air, I can say, but sooner or later we will have. So yeah. And then there's a right to object. So data subject has the right to object to its processing of data. So right to object means that you can object to the processing of your data, even though if you have consented before. Now, right to restrict of processing. So there's a very thin difference between right to object and right to restrict of processing. So what right to restrict of processing means that you don't want the company to process your personal data for any other reason. So supposingly you have by mistaken opt-in or clicked that contact me for marketing avenue, right? So that happens sometimes. So your right to restrict of processing is there. You can restrict that you do not want to continue with marketing, and you can place a request with data controller that you don't want data controller to process or keep sending you newsletter daily. So you can restrict to processing. So are the slides not on, Ashna?
No, I can definitely see them. Can you see them?
Yeah, I can see that.
Everyone, are you able to see my screen? They're on. Probably, guys, if you feel that, you're not able to see the slides, I request you refreshing your internet in that case. It's all good, Tapan. You can continue.
Sure. Yeah, so that's what right to restriction is. And now I think the obvious question pops up: what is the difference between right to object and right to restrict processing, right? So in right to object, you can ban the controller from object from his right to process your data. But whenever additional steps which the data controller has taken to process your data, and you don't want to cancel on the earlier steps, but you want data controller not to process your data for his further activities, there is what is the thin line between right to object and right to restriction of processing. Then right to erasure. This is a long debated one. We have it in India also, right to be forgotten. I mean, which was debated in the Puttaswamy judgment also, right to erasure and right to debate or right to be forgotten. So essentially in this particular right, data subject has the right to remove his data and ask the data controller to remove his data on and out throughout his system. So basically I will not get into the technicalities of how the data is being maintained, because that would be very technical: data warehousing, data control, data audits. Your project has a right to ask the data controller to erase his data from his data structures or data warehouses. But at the same time, data controller can also retain data if there are some legal obligations on them, or if there are any retention periods mentioned in a particular regulation that you need to maintain data for this many years. So there's a conflict in there, and this right is being exercised based on each scenario. Now you have right to data portability. So this I'll explain it with an example, because that in that way it would be much clearer. So we are in the process of buying car insurances, right? And we often switch from one car insurance to another car insurance, depending on the claim and the what all facilities they are giving us. So data subject has the right to ask its previous insurer to send his information about the claims, about the NEP credits and whatnot to the data controller which he has opted for his insurance this year. And this should be done, and the data controller should respect this. And when we audit, we do take care what all data portability requests were placed with the data controller and how they cater to the same, and how many days, because this is how you rate the maturity level of the audit or the practices the company is following vis-a-vis their data protection principles, or how they are respecting the data subject rights. So this is what right to data portability is. Then you have your right to complain. So it is pretty similar like we have in our Consumer Protection Act, like data subject has the right to complain about illegal processing of his data, or about his data being breached and he not being notified about it to a supervisory authority. So in EU, each and every country has to establish a supervisory authority in their country vis-a-vis the data protection laws. And each citizen has the right to go against the data controller who is processing their personal data if they feel their right is any of these rights are being infringed by the data controller. then you have right to be represented. Pretty much similar that your legal heirs can represent you in court and all of that we have in India. So I'll not push further on this particular right. It is self-explanatory due to paucity of time also. So then we have right against automated decision making. So this is where things gets interesting. And as I mentioned also, I gave an example of automating processing, right? So the the European Parliament took a constant effort to involve human to work with algorithms and not just algorithm to rule. So essentially, when dealing with this particular act and in the commentary of GDPR, what you can see by the legislators is that algorithms are there to ease our work pressure and not to do work for us. So when they say that human involvement is necessary for processing, and a data subject should have the right to talk to an executive. So I'll take one more example of Zomato. We generally chat to a chat bot, right? Whenever we have an order complaint, that is essentially an algorithm is speaking to you. But once that algorithm fails, the chat gets transferred to an individual. So essentially, it is abiding by this particular right, which I hope to see in India also sooner or later. So this is how the algorithm and man and human beings should interplay and benefit from the technology. So in toto. So yeah, Ashna, we can move on to the next slide. Now that is what the GDPR and the foundation of privacy law is all about. Now coming up, how can you build a career and what is there in the market currently? What all organizations are providing certifications? So basically, what is IAPP? So IAPP is the largest organization of privacy professional and the most comprehensive ones and the most industry oriented ones also. And CIPP is one of the certificates which is being respected in the industry. And you can check the true staffing reporting of privacy professional in order to check what is the value it holds, right? Apart from CIPP E certifications, they have many other certifications also in the field of privacy only. So they have CIPP E, which essentially caters to your comprehensive learning of European law, which is GDPR, and other European laws and the history of GDPR, how it evolved from the treaty. And there are many case-based scenario questions also which you get in the exam. You have CIPP US, which is US-centric, US laws, US privacy law centric exam, which essentially caters to your sector specific. As I mentioned during my first slide, that US laws and framework is more sector specific, health sector, finance sector, your children's sector, and whatnot. And then they have a one certification for whole Asia, wherein you have laws from Malaysia, Singapore's PIPEDA, India's IT law is there, China's POPIA is there, like that. So they have all these certifications for law, or from the people who are from the law background who are looking to build a career or strong, foothold in this privacy industry. They can go forward with these sort of certifications. Yeah, Asha, next slide. So now coming back to the CIPP, because I have given this one and I have a fair bit of industrial exposure also now, 2+ years of experience. So essentially CIPP is one of the most prestigious certifications which you can hold. And if you want to sort of penetrate into this industry, and even if you're looking for a career change also, CIPP will give you good credentials in the market. This essentially shows that you have a comprehensive understanding of privacy law, and especially of the EU privacy law, because more or less the work which I have done is based on GDPR only. And every other law which is coming up at the level of federal structure I'm talking about, I'm not talking about the state levels or the sector specific, is essentially taking inspiration from GDPR only. So you have recent, like at PDPB bill, if you had a look at it, it essentially changed the terminology. It made data controller, data fiduciary, and data subject, data principal, laying down some changes here and there. And it is being developed, for those who don't know, these are pretty big international law firms which cater in the international markets. They have governments of countries as their client, Bird, Fisher Olson's, and all of these. So this knowledge center keeps getting updated. So the exam which I gave, might not be similar to what you will give in the future, and the syllabus keeps changing. So it's not stagnant. And CIPP credentials is ANSI, ISO accredited. So ISO is another and information security sort of standards. So for all of those who have taken IT law in their law school, they know all these these bodies who come up with these certifications for the IT corporates to follow in order to have a information hygienic practices in place and data governance and data hygiene in place. So yeah, we can move on to the next slide. Now CIPP exam details. So essentially you have to register yourself on IIPP official website, purchase the CIPP exam. So you have two options. You can either take an online proctored or in the nearest Pearson VUE test center. Then essentially I would recommend you to pay once you clear the examination for the membership fees, because that made more sense to me than, because essentially once you clear the certification and pass the exam, that's not sufficient for you to enter the market and use the CIPP credentials or suffixes behind your name, because you have to be a member. Then only you'll get the ANSI and ISO stamps, which is an authorized stamp, which you'll get. It will be digitalized and it will be shown on your credential badge. So that is the process, and you can, it's pretty simple process. The exam, if you want me to throw a light on the exam format, it is basically 90 questions, 90 minutes. And it's, there are a few questions from history, but majorly there are questions, scenario-based questions. And there are they are MCQ based, but there is a concept of now multiple selective questions also, in which there can be four answers, four options given to you. Might be all four of them are correct, might be two of them are correct, might be one of them are correct. So essentially you get numbers based on that. And there's no such passing criteria which is being mentioned on the official website. But generally speaking, and it's a word of mouth, say hearsay evidence, please don't take it as an official one, but it's 60% that you have to pass in order to. But IIPP can change it to 75 and 70, and it is attempt oriented, I would say. So there is no such, and if anybody tells you that this is the passing criteria, I'm pretty sure that they're fooling you. The passing criteria is not being mentioned anywhere by IIPP, and it is not mentioned in any of the official documents. So yeah, Ashna, I think you can take it up from here.
Yes, for sure. I'm just going to stop sharing screen. All right, guys, just to have a little pause now. So as mentioned, we have a surprise for you. So stay tight. Tapan has another surprise for you as well. And we'll be doing the Q&A session, the career roadmap session after this small surprise. So we're not leaving you in the blur. Indeed, I believe each and every knowledge is incomplete if there is no application to it. So whatever knowledge Tapan has given you, he would be explaining you in a further detail towards the end of the session, where he will be giving you tips and tricks on how actually you can have a practical nuance to what you understood in the webinar today. I'm just going to start sharing my screen, everyone. Let me know if you have any trouble. Just give me a sec. Awesome. Can everyone see my screen? All right. Yes, Saurabh, we will be giving you all the details towards the end. Please stay tight. Guys, are you able to see my screen, everyone? Awesome. Awesome, guys. So this is basically a small surprise which I bought for you. So Loctopus has designed and curated this course called Technology, Media, and Telecommunication. But before this, for those of you who don't know me, I'm just going to give a little introduction about myself as well, because I am heavily involved with this course. My name is Ashna, as you can see on the screen, but I have done my bachelor's in law from India and my LLM in law and technology from the University of Ottawa, Canada. So my research area lies between the intersection of law and technologies like blockchain, artificial intelligence, facial recognition technologies, driverless cars, etc., etc. And I am trying to bring in my international exposure towards this course. So indeed, you will be learning different legislations in this domain. We will be also guiding you towards what's going on with the fintech industry in the country, what's going on with the cryptocurrency in the country, which I'm sure many of you are concerned with. Then reiterating again, we'll also be giving you one live session on privacy and data protection as well. So think of this webinar as an introduction to what we'll be actually teaching you in the privacy and data protection. There will be industry experts who will be teaching you the same. Then you will be also learning about e-commerce, liability of intermediaries, content moderation as well, meaning that we will be guiding you towards media and entertainment laws as well. Guys, we live in the age where social media, big tech industries are paving their ways in India. And India is a country which is, I believe, we are one of the largest social media users in the world. Hence, there was so many bans like PUBG or TikTok because they were taking away our data. They were taking so many things from us. And I'm sure Tapan can also agree with that why government had actually put this huge ban on these Chinese apps. They were collecting our data like that. But don't you think that these big tech industries, these new age technologies are also taking away our data? So it's not just the privacy that is concerned, it's also content moderation. There are so many issues going on with the kind of content that is put on the social media that is manipulating our politics, that is manipulating our choices. And this is why it's important for you to be an informed lawyer and an informed legal researcher, whatever career you want to choose. Then apart from this, I have personally built in a module on philosophy of law and technology. Without understanding what's the origin of law and technology or what's the nuance of law and technology, it gets difficult to understand and interpret these new age technologies. As Tapan says, it's really hard for law to catch up with technology because technology is dynamic. It changes every day. Every now and then we have a new iOS update. And this is just a small highlight to how the real tech works. But for us to be in pace with these new age technologies, it's important to have a deep understanding of how law reacts to it. This is why this particular module has been added in the new batch. Then I will also be adding a new module on NFTs. What's the legality of NFTs? What's going to happen in India? And another technologies like metaverse, IoTs, blockchain, etc. Awesome. So, mode of learning. Well, Loctopus Law School means that everything's going to be at your comfort. You can carry your law school wherever you want, whether from hills, whether from the beach or coffee shop or your cozy bed. So everything will be virtual. There will be live session as mentioned by the industry experts. We have faculty who are lawyers, who are academicians, who are researchers. There will be 8 to 10 text-based modules. There will be reading resources as well. That will be curated and prepared by seasoned experts only for you. Guys, we also have one assignment. Indeed, your law school went digital, but it's still a law school. So we'll also have a real-time assignment where we'll be giving you a feedback so that a practical element is not missing. Then we also have an online forum where we'll be resolving all your doubts. Since it's digital, we understand the trust factor is something which a lot of people have question about, like how about my doubts, how about my queries. So our discussion forum is pretty much available. We are mostly available to take all your queries, and trust me if I say that not even a single query is not unanswered. Then it's going to be a warm and caring learning experiences and support from us at Loctopus. Guys, another thing which I have personally added is this career counseling session. As I mentioned again, knowledge is incomplete if you're not able to apply it in your real life. So once you're done with the course, once you have understood all the theoretical elements of the course, we will be giving you a roadmap to your career. Let's say you want to get into a media and entertainment law. We will be guiding you through that. Let's say you want to be a privacy analyst. We will be guiding you on that. And so on for blockchain, artificial intelligence, or NFTs. Honestly, guys, foundation is very similar. And this is why it's important to understand all the nuances of law and technology. Because once you call yourself a technology lawyer, all these elements, which are these different modules, will come under you, meaning your practice would be broadened. And then you can pick a niche for yourself as a student, as a budding, lawyer, or as an enthusiast who is a recent graduate, or you have, probably you could, use this as a gift to your colleague or your friends who you feel will get some value from this course, because this is something which conventional law schools never teach. I personally was never taught about technology laws. In the name of technology laws, I was taught intellectual property rights. And guys, intellectual property rights is not technology law. And I can see Tapan smiling on that. And if Tapan wants to add something, I think, on this.
So basically, IPR and IT Act, that's it. According to law school, that's just the technology law you have in India.
Yes, so this is a piece of advice coming from the expert himself that law schools are missing out this, and this is why we developed this course. And even if you don't have interest in technology a lot, still try it out. You are a learner, you have a lot of time chilling on Netflix, but if you're able to give in some valuable time of yours towards this course, trust me, you won't be the same after the 3-month long journey. When I pursued my LLM, day one, I was a different person. 2 years down the line, I was a different person. And hence, I'm here. I'm able to educate you on this. And who knows, you will be on the other side of the table someday, maybe a leading name in the technology law space. And awesome. This is a surprise for all of you. So, all of you who are attending the webinar today, you have this waiver or the discount called Privacy 15. So if you're going to use this discount code today, you will be getting a discount on our TMT course. So I will be sharing a small form with you guys as well. And honestly, guys, after this, if you have any query, this is my email. You can all take a screenshot and note down my email. It's ashna.sethi@loctopus.com. However, now that I'm done, and then webinar certificates. So guys, certificates per se will not be, provided. However, you can still, if you want a certificate for the webinar, you can pay the logistic fee of 100 rupees. Use this particular link. I'll share this link on the chat box as well. And the certificate generation code would be TMT privacy. Again, please take a screenshot. I'll pause here for a moment if you're interested to get a certificate for yourself. But don't worry, I will be pinning this link on the chat so that it's there for you to click it right now. Awesome. So guys, this was basically a little idea about what we are doing at Loctopus, how we are adding value. And if you feel that, this course actually interests you, you're looking forward to, join me with this journey. And also another surprise, Tapan has curated, honestly, me and Tapan, we both have curated a resource list for all of you. So all those who will be filling this expression of interest form, which I will be adding in the chat box right now, will be getting access to all these free resources, will be getting access to different resources which Loctopus Law School may provide you in future. And then third would be a discount code. Let's say you're not ready to enroll today, you're ready in couple days or 3 days. Filling this expression of interest form makes you eligible to attain that discount coupon for at least 2 weeks. So Mohammed, yes, you can definitely get the certificate. I'm just pinning everything here. So guys, all of you who are interested to enroll in the course, or you're interested to get free resources from curated specifically by Tapan and me for all the privacy law enthusiasts, you can fill this form. And honestly, if you're interested for free resource or other freebies from Loctopus Law School, I highly recommend you fill this form. And I'm just going to add the webinar link, the webinar certificate link as well. Please just give me a second. Okay. So here's the webinar certificate link as well. So guys, I highly request you, we'll be starting our, so I'll be handing over the session to Tapan again. But meanwhile, I request you to take 2 to 3 minutes to fill this form. And if you have any queries, please use the chat box. If you have any questions, please use the Q&A box. Again, I will be keep coming back and forth to help you out with the expression of interest form or the webinar certificate form for that matter. So awesome. Will people upload this session on YouTube? Yes, Mohammed, this will be uploaded on YouTube. However, if you are interested to have details on when this will be uploaded, what's going to happen next, you please fill the expression of interest form, because with that, we'll have your email address and we'll keep updating you with any development in the law and technology space which Loctopus is doing. Like we do a lot of webinars, we do a lot of workshops. How much time it's going to, so guys, it's going to take 1 week to generate the certificate. So if you fill the link today, so you have to wait for at least 1 week. Meanwhile, if you have any questions, please email me at ashna.sethi@loctopus.com. And guys, please fill this expression of interest form. I highly recommend that. Trust me, if I was a student, I would have done this, because free resources, law students, this goes well together. All right, so guys, we'll be taking more queries towards the end now. I'll hand it over again to Tapan. So Tapan, do you want me to again share the screen? Okay, just give me a second.
Yes, Ashna, just a way forward slide.
Okay.
The career guardians and questions have like the normal confusions which are there.
Sure.
Last one. Yeah, thank you. So these are the basically questions which I get from my juniors, that what is the way forward? How should I build a career? I mean, we have apprehensions now, and especially with the PDP getting withdrawn, I'm receiving such questions from people like, what about you? When are you getting fired? Like there's no more privacy in India now. So it's not like that. So yes, it is a drawback. PDP got withdrawal. Yes, it is a drawback to the job market of privacy professionals as well. I will not give you some fancy hopes. But that being said, privacy bill got withdrawn. Privacy as a concept or right is not being withdrawn. It is still a fundamental right, which every big IT company, which all the MANG companies will have to abide by it if they are functioning in India. And Rajiv Shekhar has made it very clear in his public statements, wherein he says that you have to follow the rules, and they will be coming with rules. Maybe it will be something like a Digital Service Act. Nobody knows. I don't have access to power corridors in Delhi, Secretariat area. Maybe Loctopus has, so you can probably contact Loctopus or Ashna. They have access. They might have access to power corridors. So nobody knows really what will happen in the future. So if you don't know who Rajiv Shekhar is, I think you should work on your knowledge. So who he is. What is the scope of privacy law in India? So as of now, whenever I'm doing compliances for the privacy laws in India for the clients, right now, earlier I used to take into consideration PDP, but now PDP is not there anymore. We generally do it via IT Act, and in IT Act also there are RSPP rule, reasonable security practice and procedures, and sensitive SPDI rules, which are mentioned in the IT Act. So we generally take into consideration that. But that being said, I'm still very optimistic that the privacy law will come in the near future. Is moving abroad a better option to practice privacy law? It is a personal choice. I personally don't want to move abroad. I want to work in India because I think that the city I am right now is busting with the energy, with the privacy technologies, Bangalore. So it's a private choice. But yes, obviously EU has a more bright privacy career. You will get more opportunities in EU because of the fact that they have a federal legislation, but we don't right now. So obviously you will have more opportunities in abroad, especially in EU. What level of understanding of information systems is required? So here comes the amalgamation of your IT knowledge and your law knowledge, because as a privacy professional, and I can tell you from my experience, you might have to switch into different roles. You have to inculcate that algorithmic thinking in yourself as a skill, and you might have to it is an essential that sometimes you'll have to wear a cap of a privacy engineer. So you need to be thorough with the information systems. So yeah, information system, IT infrastructure, you have to know the nomenclature, the language, the ISO speaks. There are 114 plus controls in ISO 27001. You should know what it talks about. You should know about ISO 27701. You should know about ISO 29134, what all information system check mechanisms are there. So you should speak the language of engineers, because essentially as a privacy professional, you will be dealing with privacy enhancing technology engineers, and you will be working on compliance technologies. Like I am a one trust fellow in privacy technology. So in order to be compliant, you have to be, you have to work on those technologies. So you have to have that coding or sort of engineer mindset. Is coding required? No, not necessarily. Okay. That you have to know coding. It's basically if you can run any UI based interface, like we all work on Facebook, we all change our settings, we know how to navigate through software like Twitter, Facebook, Airroot, Instagram, digital marketing. A little bit of analytics is required, I would say, but not hardcore coding is required. Nobody will ask you to code an algorithm or solve a problem, or design an algorithm or train an algorithm or do a linear regression or logistical regression on a data set and all of that. But yes, once you are in the field, you will learn all these languages because you will be dealing with them on day-to-day basis. What future of privacy law in India and abroad also. So America is also coming with ADPPA, which is American Data Protection and Privacy Act, which is now being pending with the Congress. I don't know whether it will pass or not. Chances are not very good there, but every country more or less is coming with the federal structure of privacy law. America is also, it is in pipeline. If ADPPA does not happen, something else will happen. If not under Joe Biden, it will happen under another president Trump. If Trump comes up or any other, it's a political thing, so I don't want to get into that. Rest China has it, South America, POPIA, every major country, your Brazil, LGPD is there, EU, we have GDPR, Singapore has PIPEDA, South Africa has POPIA, Kenya has, African countries have, like they are pacing up with the laws. Australia has privacy laws, privacy office commissions. So abroad also, future privacy law is bright. And that's why I built a career in this particular field. So yeah. Any other questions from, and Ashna, you can take up the questions. You're on mute.
Sorry, guys, let's take the Q&A round now. And meanwhile, if you don't have any question, please feel free to fill the expression of interest form. And let's start with the question, Tapan. So first question is, so Nakib has 3 questions. What exactly is the need of a data privacy law? Is the delay of parliament necessary, as they ask that India need a comprehensive law and show intent that even IT Act will be amended or included in the fold? Who is benefiting with this great delay in the lawmaking? It's a great question. Thank you.
Cool. Definitely a long one. It will take time. So let me bifurcate it question-wise question. So the first one is whether India needs a comprehensive data protection law, right? I think yes. IT law, in whatever sort of a reading you want to do, liberal, constructive, any sort of a law, it lacks. It lacks to protect the basic tenets of privacy of Indian citizens. Okay, so comprehensive act is required. And the other question was, who is benefiting from whether the government is delaying it on purpose? I really don't want to get into that, because that is, I don't know about someone's intentions. I'm not a mind reader or something. So you can speculate that. You can speculate otherwise also. So I'll refrain from, I'll just say that much. And what was the third part of the question? Just let me have a look. Yeah. Yeah, it was basically, is the delay necessary? Like, because there's already so much. Yeah, delay, whether be the delay, I would say that yes, PDP bill, there were shortcomings in the PDP bill. Okay. But, something is good than nothing, right? And if it would have been implemented, enacted, and, effective, we would have an edge. On our edge, I would say we would have been at the world parity level. Right now, we are not even at parity with the, I don't want to degrade any country, but we are not at parity with African countries also vis-a-vis the data protection regulations and laws they have for their citizens intact and protecting them from mang and misusing their citizens' data. We don't have any of that. So yeah, We can move on to the next question. Ashna, are you filtering the next question?
Sorry, my internet was unstable, but Zoom is kind enough to catch my back. Okay.
Okay.
So, Syed has a question. Can you please repeat the case name of the Google Analytics case? I think he's asking the Google Analytics case.
Okay. It was the Google Analytics, the Danish authority case, right?
Yes. Can you?
Yeah. I'll give it's basically it's a Google, it's a Danish supervisory authority, a Danish municipal authority versus Danish data protection supervisory authority. So basically they have the in that acronym country. So I'm not able to speak up that, but you can look it up on internet.
I think we can add it in the free resources, Tapan.
Yeah, sure,
Right?
sure.
We'll be sending you the email,
that
guys.
will be done.
Please fill the expression of interest form, whoever has asked this question. So we'll be sharing the free resource. So the next question is, since India doesn't have a privacy law and the PDP bill is withdrawn, what is the relevance of GDPR in Indian scenario? Great question, Sherry.
Yeah, definitely. So the relevance of GDPR is not much, but in practice, generally what I've seen is that we take, or the companies take, GDPR as their baseline in order to comply with any law across the world. So what basically is being done is that GDPR is being treated as the mother of each and every data protection law. The compliance checklist is being prepared, keeping that in mind, the principles, because more or less the principles of each and every federal law, I'm talking about the federal law of the country, is essentially the same. So when Indian companies, we do compliance work for Indian companies, I do take care into that, and I take care of additional regulations which are applicable on my client. For example, there can be e-commerce rules 2022 which can be applicable on my client, right? There can be social media intermediary rules which can be applicable on my client, digital media ethics rules, or right. So we do take into account all those acts plus the compliance. Obviously, we don't push the client to do the compliance vis-a-vis the GDPR because there's no penal provision. You can take a leverage here and there if your processes are not up to place. But that is what is being followed in order to maintain a data hygienic practice in order to respect privacy, I would say. Yeah.
Awesome.
Good question.
So we have a question from an anonymous attendee. They say that should we have to pay for CIPPE exam and again for membership? So probably they're asking, is the exam fee and the membership fee different?
Yes, they are different.
Okay.
I don't know the cost structure, so I can't give you the exact amount. You'll have to check that.
Awesome.
Check it.
So
yeah.
Dhananjay has a question, which I'm sure many students would have. Does companies in India also have to be GDPR compliant?
Not really. Not really. But I would still recommend, if you are one of the company CEO, I would recommend you, because sooner or later the data protection law will come into the picture. So it is better to be prepared beforehand, right? Because essentially if it comes into effective, they will be imposing fines and whatnot might happen. So I would recommend to be compliant. Yeah. Awesome. You will be prepared for the Indian Digital Service Act or whatever they want to call it in the future.
Awesome. Then we have a question, how and what exactly should we prepare for CIPP exam? I think Tapan has discussed this very in detail. So whoever has asked this question, whenever we upload the webinar on YouTube, please feel free to again see this, but we have explained this in detail. Next question from Dhananjay is, what data privacy protection laws are prevalent in India? Like any rules, any laws we have to keep in mind being a data privacy specialist or a lawyer for any company in India?
Yes. So basically, as I mentioned earlier also, there's IT Act, there are SPP rule, SPDI rules, e-commerce rules. So it depends on the scenario, right? What kind of a problem is in front of you? What laws will apply to it? So sometimes what happens is, like, you can put in the cryptography law also in privacy. You have Telegraph Act, and there's a TRI regulations also on cable operators that you have to encrypt it and encrypt it in a certain technology so that the data does not get breached or the privacy is not infringed. You can give that angle to the client, but again, it would depend on a scenario based. What your client is up to, what is his business, core business, what is he providing to the citizens.
Awesome. Another question is, which is a very interesting point. What about data localization? Why is it getting so important? Great question, Nakib.
Definitely. So data localization is getting a buzzword is because essentially it is not possible for an Indian enforcing agency to access data in foreign. So you have MLAT, mutual legal agreement treaties with countries in IT Act, and there's a provision for the same, but it does not work. It is not effective to cache the data. So essentially each and every country or a big powers, you can say, they want each and every company, mang company especially, your Meta, Apple, and followed by other companies, that they have to keep the data of their citizens within the territory of the country. So that is why data localization is important, because it gives a tool to the state and state agencies to enforce or do surveillance on their citizens sometimes. And we have seen that it has been done in many states, like countries like China. So it is a tool in the hands of the states. So that's why data localization is important.
Awesome. And guys, please don't use the chat box. We're not going to take any question from the chat box. Only use the Q&A box. This is why a tool has been created by Zoom. Make the most use of technology. So please take your questions from chat and copy it on the Q&A box. So the next question, I think, how about making a career in a cyber field as a lawyer? This is not relevant. We are talking about privacy today. So we might take this question in some another webinar, Aniket. Thank you for your question, though. Again, another question, what is a better option, IPR or data privacy? Again, we have spoken a lot about data privacy today, and it's for you to decide whether if it's a right career for you or not. Then we have a question. It's up to you, Tapan, if you're comfortable to answer this. But this person is asking, how much are the privacy professionals paid?
Yeah, that question came up. So basically, you can check the true staffing report. Okay, how much privacy professionals make, and what is the salary in different continents, and you will find your answer in that particular report. It's
Great.
True Staffing Privacy Professional 2022 published.
Awesome. Are there any law firms?
Just true is TRU, not TRUE.
Okay, great. Are there any law firms or institutions that people might approach for internships, etc.?
There are many. I mean, you can approach DSCI, Data Security Council of India. They have their internships and they have their, they deal with privacy and public policy simultaneously. So that's a good organization to work with. If I would have been a law student, I would have gone for that. There are many startups which are coming up in the field of privacy technology, but again, you need to have a little bit of coding language or engineer, because they are not taking law students per se or to intern with them. They might give you another work which is not related to law. But DSCI is a good place to work with. I would recommend everyone to check that organization out.
Guys, we have an interesting question from an anonymous attendee again. So they're saying, isn't the feedback form blatantly violating the privacy law, where we have only given one option, whether yes, if you want to fill the form? So guys, in that case, I will ask Tapan, what should we do? So if a particular organization is giving one answer, can we, if I were to answer this question, I would simply say, ignore the form, close it. What would you recommend, Tapan?
I'll have to look at the form, but basically this is a classic case of cookie compliance. So there's a concept of opt-in and opt-out, right? So basically when you go on a website, if the website is EU operated, you will get a pop-up or a cookie pop-up of opt-in, right? And you will have to check that only necessary cookies. But in America, especially in California, because California is like a hub in America, it is like their economic hub. There you have an option of opt out. So basically it is all pre-ticked, and they assume that when you are coming on a website, so you have consented to be tracked on internet. But from my understanding, and from various CJEUI judgments, Court of Justice, European Union, they have said that the only necessary cookies should be labeled on the user's system and not unnecessary cookie for your data analytics and for your data scientists to experiment upon. So to me, and I'm not, again, it's a disclaimer to Octopus that I have not read and gone through your form as of now to give any sort of a privacy advice or legal opinion on the same. But I would think that uh, the person who's filling the form should have more options, to get, and this should not be yes or no, because at the end of the
Definitely.
day, yeah, you have to
It
have a
could
purpose.
honestly, it's probably a glitch. I mean, we are not taking away anyone's data, but guys, honestly, if situations like that happen, you can simply cross the form. I mean, it's up to you whether you want to give in your information or not and be an informed citizen. This is what we have learned from today's webinar, right? So we'll
Yeah,
be taking a couple more questions, Tapan, and
sure.
you have the Q&A box. You can see which questions are most relevant that you feel should be answered today.
Sure. So there's a question: what can be the future prospects of lawyers to practice in IT/AT and try? I'm not the right person for this question because I'm not practicing IT/AT. Tax law is not my thing. So what's cookie and how does it work? Yeah, I can take this up. So cookies are basically small files which are laid by the website or whatever website you are visiting. So they collect data from your system, your IP address, your location, your scripts, and all of that information. And then they can track you. They can track your previous visits and sometimes analytical cookies. And these are sort of a parasites which they lay on your system once you visit their website. So there are 4 types of cookies. I'll not get into the details of each and every one. They're strictly necessary cookies, they're functional cookies, they're analytical cookie, and there are others cookies. So these other cookies are the most dangerous one. Do not take them. Do not give consent to any website to track you, because they essentially track your all processing, whatever, wherever you're going, and they do it for years. Okay. So you might not know, you have visited some file, you have given a consent, but they know that whatever you are shopping, whatever website you are visiting, okay. So like that. So these are cookies. Okay, so what all resources would you recommend to develop understanding about different aspects of privacy law, and as a law student who is not necessarily related to tech field, to develop language spoken by engineer, coding language that you talked about earlier? So, okay, it's a good question. So for privacy law, there are many commentaries of GDPR which are coming up and available in the market. I will not recommend you to buy each and every book of privacy law per se, but you can obviously ask your librarian to provide you with access, because these books are really expensive. So you need to have a financial backing of your institution. At least that's what I had from other institutions. And if you are in Delhi, you can access libraries like International Law Center, which is near to Supreme Court. They have good materials there. Okay. And vis-a-vis coding, again, it depends on your personal interest, how enthusiastic you are to pursue a career in it, and at all, because essentially coding is just another skill in your armor which you can use it, uh, which you can use to sell yourself is not the right word, but to portray yourself in the job market as an eligible candidate with an additional skill as compared to your other folks. Because if you are in privacy and you have a coding background, you will have an edge over other applicants, that's for sure. As a fresher, how should one start his career in data privacy? I'll recommend Sagnik to go for internships with DCSI, to write about privacy law, to get your papers published in good journals, gather knowledge as much as you can, right? Because right now I can see the knowledge infrastructure in India is lacking about privacy law, and I've suffered because of that. So I can relate to this question. It can be tough, but at the end of the day, you will have to work out your own map. So yeah.
Now let's take the last question, Tapan.
Sure. So there are so many questions. I'm just confused which one to take. Is data protection laws and data, okay, I'll take this file. Sorry if I'm pronouncing your name wrong. Pile Kanjilal. That is data protection laws and data privacy and cybersecurity laws one and the same? No, a big no. Okay, there's a altogether difference, and once you get into the field, you'll understand more. Cybersecurity law deals with information security, and data protection law deals with the privacy, data protection, data breaches. There's a difference between information security systems and data protection mechanisms to be in place. So there's a altogether different. I mean, obviously, cyber encompasses everything. It's a bigger ocean. In cyber, you have data protection, you have information security, and others. So yeah, I'm done, Ashna.
All right, guys. Thank you so much for joining in today. And Tapan, it was a wonderful experience for me as well. Coming from a technology background myself, I feel privacy is one topic which is in a flux, especially in country like India. And you have answered so many questions. I deeply apologize for everyone whose questions are left unanswered. However, you can email me on ashna.sethi@loctopus.com with all your queries, and I would love to answer them. And thank you so much again, Tapan, for bringing in this wonderful experience for the privacy law enthusiast in this society. It's a niche indeed. And for those of you who are watching this future, again, kudos to you because privacy will be the future. And with this, we end today's webinar. Again, if you're interested to enroll in one of the courses and know more about privacy, you can fill the expression of interest form on the chat box. If you're looking this in the future, you may have an email where the expression of interest form is mentioned. And have a good night, everyone.
Thank you, Ashna. Thank you. Thank you
Bye.
very much for inviting me. Thank you.